All right. Good afternoon, everybody. Keith, I cannot believe that all of these people have shown up to listen to us talk about Article 3 of the Constitution.
I don't think that's what they're waiting for. That was yesterday.
And how it applies to federal judges.
Yeah, no, I think today we're talking about a little different subject.
Are we talking about a different subject today? So first of all, thank you for everyone who's showing up and joining us today. I know the title. A lot of people were wondering, is it clickbait? Whatever the case may be. I just want to say this up front, and that is, look, not everyone's going to want to hear what we have to say today. This case is not over, by the way. This case is nowhere near over. So feel confident. But we want you to know we're going to be honest with our review. And we've been waiting for something like this to come along, something that meets our standards of wow. And this did meet it. And we want to walk you through and give you our opinion. It's just our opinion, folks. We can be wrong. I don't think we are, but we can be wrong, and nobody knows which way the judge is going to go with this. But still, this is an outstanding document. I think that Esra Hudson, who's the attorney that drafted this, at least she's the one that signed it, she did a phenomenal job. Her team, I'm sure, helped her along the way. And we want to walk through the arguments that she's given. And I think there's also some things that we didn't consider fully based on California law that are going to be very helpful for Blake Lively, not only in the 12B6 motion here, but in this case moving forward. So with that being said, Keith,
and I think we also want to point out the weaknesses too. Sorry.
We definitely do. But so we know you're trusting us with our analysis here. We don't want to disappoint people, but we do want to give you an honest review of what we've taken a look at.
Yeah, that's right. Yeah. And then it will be our honest opinion of this. And it is a pretty good punch coming out of the Lively camp. But we'll also point out areas where we think that there's some weaknesses and some opportunities for Brian Friedman to come back on the Baldoni side as well.
Eric, can we quickly put up Esra Hudson? I always like to give a little bit of credit to the lawyers that do this drafting. Again, where is she from, Eric? Can you give us a little background?
Esra A. Hudson at Manat. Manat, Phelps and Phillips is the firm. She's based out of LA. She went to school, law school at UCLA, did undergrad at the University of Wisconsin, Madison. Has quite a bit of honors and awards recently, or throughout her whole career, and seems like a wonderful attorney.
All right, so Miss Hudson, Esra A. Hudson, a California attorney. We're California attorneys. She looks like she took the lead on this, and I'm sure she had people helping her with this, paralegals, associates, and other partners. But kudos to them for putting out such a good product.
Yeah.
All right. Why don't we jump to? I just want to jump to page 1 just for a minute here, Keith, and I know you wanted to jump to page 2, but let's just see how this starts out here. And this is the introduction to the argument. I think it's put together quite nicely. And it says the Wayfair party's vengeful and rambling lawsuit against Blake Lively is a profound abuse of the legal process and has no place in federal court. So whenever you're putting a first sentence together like this in a brief, it's an important place to put it. And here they don't miss a beat, and they just simply say, this is not a good lawsuit, shouldn't be here in federal court. And then they're going to tell you why. The law prohibits weaponizing defamation lawsuits. And that's important. What law is she referring to there? We're going to get into that. Is there a law that prohibits the weaponizing of defamation lawsuits? And does it apply to this case? She says, like this one. So she thinks it does apply to this case. To retaliate against individuals who have filed legal claims or have publicly spoken out about sexual harassment and retaliation. The right to seek legal redress and the right of the press to report on it are sacred principles that are protected by multiple privileges. And so we're going to get into some privileges today. Keith, I know you're ready to break those down for us, but the 3 privileges we're talking about are the litigation privilege, the fair reporting privilege, and she's saying that those are absolute. There's also the sexual harassment privilege, which is an enhanced litigation privilege under California law, and we'll get into that in just a few minutes.
And we kind of saw that one coming. We've talked about 47.1 before, so I'm not surprised to see that here.
In fact, that 47.1 comes in the next sentence. Moreover, by choosing to bring their claims under California law, the Wayfair parties have voluntarily subjected their entire lawsuit to the sexual harassment privilege. That's the 3rd privilege we're going to talk about today in the recently enacted California Code of Civil Procedure 47.1. And Keith, when did 47.1 become effective?
January 1 of 2024. So yeah, that's a law that's not even 15 months old.
Not even 15 months old. And we're going to see that this law is somewhat devastating to some of the claims that are being made here. And what 47.1, it bars retaliatory lawsuits based on public disclosures of sexual harassment and related allegations, including disclosures to the press. And then and I could keep reading on. Everybody else can read this, but this is something else I want to point out. And then Keith, we'll turn it over to you. The attorney here goes on to say, on top of that, Section 47.1 contains a mandatory fee shifting provision that will require the Wayfair parties to pay not only Miss Lively's attorney's fees, but also treble damages and punitive damages. Of course, those would have to be proven if and when their defamation lawsuit is dismissed. And she gets a little strike at Steve Starowitz here when she says that Steve Starowitz may indeed make good on his threat to spend $100 million litigating against Miss Lively, but perhaps not in the way he planned.
Well, that's kind of funny. I didn't really pick up on that until you pointed that out. Okay, so a little bit of a jab at Starowitz there, and we will see how 47.1 can be devastating, but there are certain hoops you have to jump through for 47.1 to apply. And so we'll get to that when we get to the argument section. But I want to first cover the first paragraph on page 2 and the 2 bullet points. So essentially what they're arguing here is that among its many additional incurable defects, so she's talking about Baldoni's first amended complaint. And remember, this is Lively wanting to dismiss the first amended complaint claims against her. They're saying that it does not allege a single element of the defamation or false light claims properly. And so we're still at the dismissal phase. We're only looking at what the allegations are. We're not looking at the evidence. We're only looking at whether or not the allegations are properly brought and properly pleaded. And it says, starting with the failure to allege defamatory statements with specificity, instead lumping all plaintiffs together as an impermissible group pleading. So we've seen the group pleading thing brought by other parties as well in their motions to dismiss. New York Times said it. Leslie Sloan said it, and now Lively saying it. And so they're saying that really there's just 2 principal categories of defamatory statements, and those are those 2 bullet points there. So allegations that Mr. Baldoni and Mr. Heath engaged in sexual misconduct towards Miss Lively, and allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she reported their purported misconduct. So those are, according to this argument in this brief, this motion, those are the 2 categories of defamatory statements in the first amended complaint. And they're going to say, well, that's not enough. You need more specificity than that. So, and then let's go to the very last paragraph of page 2. It starts with yet another of the FAC's insurmountable deficiencies is its utter failure to allege actual malice, i.e. that Miss Lively subjectively did not believe the sexual harassment allegations she raised. So they're saying that Baldoni did not allege that Miss Lively subjectively did not believe those sexual harassment allegations. I'm not so sure about that because I know in Baldoni's first amended complaint, he talks a lot about Miss Lively's overall scheme to take over the movie. And I think that a lot of that is going towards that she had an ulterior motive when it came to what she was doing. And it seems to me that could form the basis or the factual basis for actual malice. But it'll be interesting to see how Friedman responds to this. But that's the argument that Lively's attorneys are making. So the next thing I have is down in page 5 when they're talking about the background. Did you have anything before that?
Nope, we're
Okay.
fine.
Yeah, that's it, the part that you have highlighted there. So in other words, this is her background on the issue. So the first amended complaint acknowledges numerous onset incidences. So what she's saying here is that the first amended complaint actually says that these things happen. According to the first amended complaint, each of the following incidents occurred. And it talks about after the first day, Mr. Baldoni entered Miss Lively's trailer to voice his concerns that Miss Lively looked unflattering in publicly released photos. During the meeting, Mr. Baldoni became emotional and told Miss Lively that he thought her appearance was failing to meet audience expectations. So they're talking about this coming out of the first amended complaint. And I guess it has paragraph numbers on here too. So I didn't compare this to the first amended complaint, but essentially the reason why she's reciting all of this is she's saying these are the facts that are in the first amendment complaint, which is what we can look at. that go to my claim that I had the right to make SH claims when I made those claims under the CRD in California. So this is setting up her argument. That's the reason that she has those facts in there.
Here, real quick, I just wanted to jump in. This is an aside, but Robin K said, but the California law protects people from disclosure of SA, not from the fabrication of SA, and whether it is disclosure or fabrication, is that something for the jury to decide?
Yeah, we're going to get to that, and it could be. I mean, certainly the fabrication would be a factual issue, but we're going to cover that when we get to the privileges. That's an important issue. So let's cut down. I want to start on the arguments. So the first page of the arguments on page 10, and they're saying that all the parties agree that California law applies to all claims against Miss Lively. So it says that the Wayfarer parties assert their claims under the substantive law of the state of California. So while other parties may dispute that a proper choice of law analysis would permit application of California law to the Wayfarer parties' claims against them, Miss Lively agrees that California law applies to the claims asserted against her. Now, here's the interesting thing. Baldoni did say that California law applied when in his defamation lawsuit against the New York Times. We went over that. I don't remember him saying anything in a pleading where he agreed that California law should apply to Blake Lively's sexual harassment claims. But Lively is saying that California law should apply to the SH claims in my lawsuit. And she essentially is saying, well, Baldoni already said that California law should apply to him, so it should apply to me too. I think the one issue with that argument is choice of law provisions can be different for different claims. So just because the defamation claims for Baldoni against the New York Times is based on California law doesn't necessarily mean that the SH claims of Lively is going to be based on California law. And so it's going to be interesting, and it's going to be important when we start talking about these privileges, I think, to determine whether it's California or New York law that's going to be applied here, because it could have a dramatic effect and difference in terms of how this all shapes out on the motion to dismiss. Don't you think, Stuart?
So I think this is I think Esra Hudson was in her office when the opposition to the New York Times motion to dismiss came in from Team Baldoni. And Team Baldoni did a very good job in that opposition of pointing out that California law is going to apply. They talked about how all their plaintiffs are in California, Wayfarer's in California. Even Steve Sarowitz, though he's not in California, he's part of Wayfarer, so he's part of California. So they kept drumming California law. In fact, I even said they're saying California a lot of times here. And I can just imagine Esra Hudson, who is the attorney for Blake Lively, jumping up and down in happiness and glee, because California law is, if it does apply here, it has provisions in it that New York law does not. Now, I don't know much about New York law. Maybe there's an equal provision in New York law, but I don't think there is. I think California law, California codifies everything. California law wants to touch everywhere in our life, on everything we do, including these SH claims. And they wanted to bring 47.1 into this. And so if California's Code of Civil Procedure 47.1 applies, this is going to be a problem for the Baldoni team going forward. It's not insurmountable, but it is going to be a problem if California law applies. So I think kudos to the ability to point this out here and to say, hey, California law applies. I think you're right, Keith, that each claim has to be measured from a conflicts of law standpoint. So from one defendant, California law can apply. Another defendant, New York law can apply. So does Baldoni come back in a second amended complaint, or just come back in a filing and say, no, it's New York law that's going to apply to this? I don't know. But California law, as we're going to see here in a few minutes, it's really good for Blake Lively and not so good for Justin Baldoni.
Yeah, and that's because of the provision that was enacted in January 1, 2024. And she literally says that, Lively says, and this is at the very top of page 11, that in a complaint filed with the California state agency to seek relief from a California employer's violation of California law. So Again, she's saying that everything should be California because the Wayfair parties are California. They're a California employer. I haven't seen anything from the Baldoni side yet that talks about choice of law and what their argument is on that regard. But I'll bet you anything that they're going to argue against that because it would be pretty clear that they'd want to. Now, let's go to the subsection A at the bottom there on page 11. So this is really what we're getting into. So the heart of this whole brief and the heart of this whole argument is the defamation claims fail because the Wayfair parties failed to identify specific and unprivileged statements. So the real thrust of this entire argument, and probably the strongest point they have, is they're talking about you haven't pointed to anything that doesn't have a privilege. What privileges are we talking about? It's the one that you covered in the introduction, Stuart, which is the litigation privilege and the fair reporting privilege.
And there's another privilege.
And the SH privilege.
Yes.
Which really is an enhancement on the litigation privilege in California.
And that's because it's 47.1. Is that right?
Yeah.
Okay.
So the regular litigation privilege is Civil Code Section 47. The SH enhanced privilege is 47.1. And we'll look at that in just a second here.
Here, I'm going to jump in for a second, if you guys don't mind, because this is what a lot of people are echoing and have the same question. MKJ says, if the alleged SH took place in New York, wouldn't New York law apply?
Arguably, yes. And I think that's where it's going to be very interesting to see how Baldoni comes back and argues this, because their argument is probably going to be just that it happened in New York, so shouldn't that be where it applied? The New York law should apply. Lively saying, well, wait a minute, these are California employers. They're operating under, California law in some way. I don't know exactly how, and therefore California law should apply. It's going to be a big deal. I mean, the choice of law on this SH claim is going to be huge. So let's go down to the first privilege. And I think that, I guess before we get to the privilege, they do have a statute of limitations argument on page 13. So they're saying the statute of limitations bars defamation liability premised on statements made before January 7th, 2024. So again, they're pointing to California law here. And under California law, there's a 1-year statute of limitations. And so they're trying to say that in order to survive a motion to dismiss, the defamation statements must be premised on statements made on or after January 17, 2024. I'm not so sure about that because I think that these statements were kind of made again and again. I mean, you kind of have the statements and the 17 points or that Lively demanded before she would go back to production after the writer's strike. But then that same content was also said again later on in the CRD complaint and in the information given to the New York Times. But that's the argument, that there's a statute of limitations claim here. And then let's go down to, page 15, they start off the section saying that there's multiple privileges bar the defamation claim. Okay, so the defamation claim must be dismissed because the First Amendment complaint is missing a key element of the Wayfarer party's affirmative pleading burden. Specifically, it fails to assert that Ms. Lively's alleged defamatory conduct was unprivileged. Okay, let's get into the privileges then. And on page 16, we're going to start up with the fair reporting privilege. So the fair reporting privilege in California, there's also a change that was made to Civil Code Section 47 and subsection D. And it literally says that it's not just the fair reporting of an official filing that's protected by the fair reporting privilege, but it's also any communication to a publication that's going to publish that. So for example, let's say the Los Angeles Times could take a complaint that was filed in court and can report on it as long as their report is based on that complaint and they're covered by the fair reporting privilege. But the lawyer who filed that complaint for one of the parties is also protected by the fair reporting privilege if they communicate that complaint to the Los Angeles Times. And so it's the fair reporting of the story that's covered, but also the communication to the LA Times that's covered. So it's really interesting that in California, the fair reporting privilege covers both actions. So essentially what they're saying here is that the CRD complaint itself is covered by the fair reporting privilege, or well, that's covered by litigation, but the CRD complaint, when given to the New York Times, was covered, but the communication of it by the Lively camp to the New York Times is also covered by the fair reporting privilege. That's their argument.
I think
Yeah.
47.1, the amendment, it creates a bridge between the litigation privilege and the fair report privilege, because there was a case that actually came down in California where the one privilege was granted, but the other privilege wasn't. And so 47.1, according to the legislature, fixes that, because now it has both privileges attaching to this type of disclosure.
Well, at the same time that 47.1 came in, the subsection D of 47 came in, and it was also effective January 1, 2024. And so, yeah, that's what they did, is they closed the gap here. And so if this is going to be decided under California law, then both the CRD complaint and the transmission of the CRD complaint to the Times would be covered on the fair reporting privilege. Now, I still, in my mind, question, yeah, but what about the other documents? I mean, what about all of these various text messages? And, there's supposedly 1,000 other documents. That's not part of any CRD complaint. It's not part of an official filing with the court, so it wouldn't be covered by Section 47 of the Civil Code. And so the communication of it to a media outlet presumably wouldn't be covered by that privilege. So I'm wondering if there's some argument there to be made by Brian Friedman to kind of counteract this argument about the fair reporting privilege.
I'm sure he'll have to make an argument there, but it seems like 47.1, the new law that was passed January 1 of 2024, is quite broad, quite encompassing, includes whether a complaint is filed or isn't filed, as long as a person is reasonable based upon a SH claim that they believe that they've undergone, and they haven't stated it with malice.
So let's look at that. It's on page 18 where this section starts. So California adopted a new section on January 1, 2024, and it extends the litigation privilege to a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under Section 47. So any communication made by an individual without malice regarding an incident of SH. I mean, think about that for a minute. That's not an official filing with the court or an administrative agency. So it used to be that the litigation privilege only applied to a filing with the court or an administrative agency or a government body of some sort. 47.1 completely blows that wide open, because 47.1 will actually apply to any communication. It says it right there in the middle. Communications made by an individual without malice regarding an incident of SH. That's really broad. That's really broad. But you do have to do it without malice. That's one exception.
And you must be reasonable.
And there's another exception, that the section only applies to an individual that has, or at any time had, a reasonable basis to file a complaint of SH. So if you don't have a reasonable basis to file a complaint of SH, then you do not get this privilege. The privilege is gone to you.
That's kind of what I think. I don't know. I could be wrong, but one of our jury pool members says, doesn't fair reporting privilege only protect one if the claims are true? I mean, it's a claim, but Megan Toohey said that they reviewed thousands of pages of documents before publishing the article.
So not necessarily. So the fair reporting privilege protects any official filing with the court. And remember, when you file a complaint with the court, you're just filing allegations. And so anybody can say anything they want, really, in allegations. It's not evidence. I mean, you're not supposed to knowingly lie when you file a complaint, but it doesn't have to be 100% known when you file a complaint either. And once you file that and it's reported on, that's covered under fair reporting privilege. I think the thing that's interesting about this 47.1 is it really expands what's protected by the litigation privilege as any communication made by an individual regarding an incident of SH. But there's two requirements. You can't have made that statement in malice, number one, and number two, you have to have a reasonable basis to file a complaint of SH. So this comes back to the whole strategy of you file a CRD complaint in California. Why do you do that? Number one, I think you're doing it because you think California law applies, Or number two, you're doing it because you want the protection of Civil Code Section 47.1. That's a pretty strong protection.
I think we just step back here just for a quick second while you're going through this, Keith. 47.1, if you think about what the legislature was trying to do, and I don't know if you were going to get into this or not.
No, go ahead.
But what was the legislature trying to do here? Whether you agree with the legislature or not, we got to try to understand what was the purpose of doing 47.1. So 47.1, the genesis of it was the Me Too movement. And you have women and some men that have filed lawsuits against powerful people. And when they file those lawsuits against powerful people, in many cases, those powerful people end up suing the person complaining of SH for defamation. And so the idea behind 47.1 is we're going to cut that off at the knees. We're not going to allow people to sue people who come forward with SH because we want to promote people coming forward with SH. We don't want people attacked when they bring forward SH claims. And so here, what they're trying to get at is that Blake Lively brought SH claims and then she was attacked for that, which the law doesn't allow for. Also, her speech on this, when she communicated this, if she did communicate this to the New York Times, we're pretty sure she did, but we need proof of that. If she did communicate that under 47.1, she's entitled to do that. And there can be no ramifications to her for disclosing that, even if she didn't file the CRD complaint.
Right.
Even if she didn't file the New York filed second district complaint, even if she never filed a lawsuit at all, if she was reasonable and was not doing it with malice, this is a very broad statute and it is very powerful for Blake Lively.
So think about how this argument is constructed. And this is why really Esra Hudson did a brilliant job in weaving this together for the Lively camp. And, you know, you're talking, really, it all starts with the idea. And again, she's saying, based on the allegations, they have not alleged anything other than these SH allegations that Lively, you know, allegedly had. And under California law, Lively was allowed to communicate them. You can communicate an incident of SH,
including other papers.
Doesn't have to be filed with the court. You can make your CRD complaint if that's what you want to do. Still can't be sued for defamation. And once you make that CRD complaint, it's covered not only by the litigation privilege, but you can communicate it to the Times, and it's covered under the fair reporting privilege. And because of that, all of those privileges coming together to protect anybody in this situation, there has not been allegations in Baldoni's complaint that would overcome that, and therefore this should be dismissed. Just the way that whole analysis comes together and the way that it's all brought together, it's really a strong argument. Now, there's two ways I think Baldoni can argue against that. One is we don't think California law applies to these particular claims. Let's get it out of California. We got to get away from this 47.1. That's the first thing. And then secondly, I think you have to say, well, wait a minute. We did make allegations that there was malice, and we did make allegations that Lively did not have a reasonable basis to bring an SH claim. Or if we didn't make those allegations well enough, then let us do an amended complaint. We'll do a second amended complaint and we'll clean that up and we'll say more things about that.
Yeah, that's right. And also the issues of whether she was reasonable to bring this or whether there was malice. I do believe that is a determination of the jury because that's a finding of fact. And so again, this is a 12B6 motion. It's to dismiss the lawsuit even before you get in front of a jury. And by the way, there's more paper wars to come. There'll be motions for summary judgment down the road after depositions and discovery are completed. But right now we're just at 12B6. And so what they want to do at all costs, if you're Baldoni, you want to get past this phase. Because if you get past this phase, you're getting closer to that jury trial. The problem is under California law, as I see it and as I read it, you're limited to two issues. And that is, was she reasonable in what she did in making these claims? And secondly, did she have malice when she did this? And if she wasn't reasonable, well, you can hold her accountable for that. And if she did have malice, you can hold her accountable for that. But those aren't great claims to make the way that I'm reading the statute.
I'd rather get out from under the 47.1 section of California if I could.
I think a lot of people are wondering this. How do you prove it was without malice?
Yeah, that's hard to do. And I think, well, I think that goes to the allegations in Baldoni's complaint where she says Lively has an ulterior motive in everything she did. And so when she brought forward her SH claims, what she was really doing, according to the allegations by Baldoni, is she was trying to take over control of the movie. She wanted to take over all, every aspect of it. And then I think there also were some claims that she was angling to ultimately take over the sequel to the movie. But to the extent that those allegations are in Baldoni's First Amendment complaint, I think those are the types of facts that would go towards, is this a person who honestly was making an SH complaint, or did she herself have, either she knew that her complaints were not true, or she had serious doubts as to the truthfulness of those statements? That's what actual malice is. And so I think the more that you can show an ulterior motive, then you can start getting the jury to see that maybe this person was not acting in the best in truthfully, but she was trying to do something else.
Yeah, I think I'm just going to one more comment because I think it speaks to this comment. JT says that's such a tricky privilege. I agree that victims should not be attacked, but when someone does this as an agenda that is just so tricky, it could be dangerous in the wrong hands. And yeah, it's like it's put in place to protect victims and have them not be attacked. But
can you put the complaint back up on the screen, Eric?
Yes.
So here's what Esra Hudson had to say about the malice claim. And she says, for the same reasons, the First Amendment complaint also fails to plead malice sufficiently to overcome application of the sexual harassment privilege under this new section 47.1. Although neither section 47, which is the litigation privilege, nor the 47.1, the new law, define malice, courts rely on section 48A's definition of actual malice as the governing standard. And under section 48A, actual malice is defined as a state of mind arising from hatred or ill will toward the plaintiff. However, the section further clarifies that a good faith belief on the part of the defendant in the truth of the libelous publication or broadcast at the time it was published or broadcast shall not constitute actual malice.
Okay, that's really interesting. So let's look at that. Is defined as state of mind arising from hatred or ill will towards the plaintiff. So that's why all of those allegations going towards Lively's ulterior motive, according to Baldoni, is going to help in trying to prove actual malice, because you're trying to show a state of mind of hatred or ill will. So you're going to be showing what really was going on here. But Lively can get out of it if she can show a good faith belief on the part of the defendant in the truth of the libelous public. So if she had a good faith belief, I mean, those are very tricky things. A lot of play in those words, a good faith belief by the defendant. I mean, there's just a lot of play in that.
And I think this is, again, an issue, malice, we've already talked about. That will go to a jury.
Yeah.
There will be jury instructions. They'll be fought over jury instructions I'm sorry, go ahead.
No, I'm listening.
They'll be fought over by the plaintiff and the defendant in this case. So Blake Lively and Justin Baldoni's team will be arguing over what jury instructions are given to the jury on what malice is. And right here, I'm reading this and I'm having to slow down and I'm having to really think about it. And then, of course, is the malice because it's the facts based on anything other than SH, but they lead to the SH because there's malice there? Or is the SH the malice? And then is there this exception where, well, did Miss Lively have a good faith belief on her part that this wasn't a libelous thing to do, and she really felt convinced that she had been wronged? That's for a jury to determine. And if a jury determines that she did this in good faith, then it's a shall requirement. They cannot find actual malice
if they find that. But I'm really looking back at the state of mind. I mean, actual malice is defined as the state of mind arising from hatred or ill will towards the plaintiff. I mean, there's just so much that Baldoni can point to that I think kind of goes towards hatred or ill will. So really what they need to do is they need to get past the motion to dismiss either by, winning it, or restating their complaint with a second amended complaint and get this in front of a jury.
Yep. Any other thing you wanted to cover in the complaint, Keith?
Can you bring that comment that you had up again, Eric? I wanted to just say something. You had a comment up a second ago. Oh, about how tricky. I want to talk a little bit about how tricky 47.1 is. So yeah, the legislature in California passed that to help protect people who need to come forward with SH claims. And it is an important law because I think the perception and often the reality in many of these SH cases is that the person who's the victim is without power and the person who's the victimizer is the powerful one. And so I think you do need protection of that. But it is interesting, isn't it? And this happens sometimes in the law, where a law that's meant to protect people can also be used by maybe somebody who doesn't need that protection. And so you can have different results and different outcomes based on that. But that's why the law does have some exceptions. And that's why malice is important. And that's why reasonable basis to bring the SH claim is important.
Anything else you wanted to cover in the complaint, Keith, or the motion?
I don't think so. She did cover something about there's no private right of action to sue for civil extortion. But I think California does actually have some case law, especially at the federal level, federal courts who've interpreted California law, that you can sue for civil extortion.
So one other thing I wanted to cover is this last section on is Miss Lively entitled to attorney fees, trouble damages, punitive damages. So the general rule under the American system for all of the United States is that every party, whether you're a winner or a loser, you have to bear your own attorney's fees. So if I sue Keith and Keith sues me back and we sue each other for 5 years and we both run up $1 million each in attorney's fees, under the American system, whether I lose or win that case, I have to pay my lawyers. You have to pay your lawyers. You're not required to pay my lawyers. I'm not required to pay your lawyers. There are two exceptions to when attorney's fees will be shifted to the losing party, or if there's a prevailing party, the prevailing party can shift their attorney's fees to the other side. What does that mean?
Shifting the attorney's fees?
Yes.
It means that the other side would have to pay. So the losing party would have to pay the attorney's fees for the prevailing party. And
what are the two exceptions, though, to the general rule?
Contracts. Okay. And so if there's a contract that allows for fee shifting, and then there's limited statutes. So there's certain areas in the law where the law does allow fee shifting. And, section 47.1 is one of those rare exceptions.
And here, essentially, if Miss Lively is defined as the prevailing party, which there's a whole analysis that is done under case law and statute to determine who the prevailing party is, it's generally the party who wins. She can get all of her reasonable attorney's fees and costs. The costs are obviously much smaller than the attorney's fees, but in a case like this, they'll be large. But then she gets treble damages, 3 times the amount, and then she can get punitive damages under section 3294. And punitive damages, those are meant to punish, and those can be extreme. They can be large. So many people in California, when there's a statute like this that's being used against them, where there's an attorney's fees provision, they settle the case just from a business standpoint because they cannot leave it up to a jury to determine. Because if a jury finds that Ms. Lively is the prevailing party and maybe they only give her a small amount of money, you're entitled to that small amount of money, but then you're also going to get all your attorney's fees. You're going to maybe get triple damages. You're going to get possibly punitive damages if you can make that prove up. That's a lot of money to have to pay at the end of a lawsuit.
Okay, so just to put this in perspective, so Lively sues Baldoni for SH, and then Baldoni turns around and sues Lively for defamation. If he loses, he has to pay, under this statute, he has to pay her attorney's fees, he has to pay treble damages, and he has to pay punitive damages.
And whatever the jury says he has to pay.
But if he wins, Lively does not have to pay his attorney's fees and does not have to give him treble damages and does not get punitive damages.
It's almost like going into a UFC fight or going into a football game where the other side is just a little bigger, a little stronger. They've got a little bit more on their side. Doesn't mean you can't beat them. It's just, it puts you at a little bit of an unfair advantage. It's almost like racing somebody in the 100-meter dash and they've got a 20-foot head start on you.
I mean, it's high stakes poker. So one side is taking a bigger risk than the other side in this lawsuit because the law provides for that. The law provides one party with more remedies than it provides the other parties.
And that's why I'm somewhat, this when I read this today, I was just blown away of how well this was put together. And I had not really taken a close look at 47.1. You had looked at it previously. We've looked at it again after Esra Hudson pointed out how powerful it can be. And it leads me back to, even though Ryan Reynolds filed his own 12b6 the other day, that I felt was just too harsh. It didn't really make its points well. It caused fights where it didn't need to. It caused insults where it didn't need to.
It wasn't like this.
It wasn't like this. It wasn't well drafted and put together and stringed together so nicely. And so this then leads me back to, at that point the other day, I was like, I don't think this case is going to settle. They painted Justin into a corner. But I think you got to take a moment and look at this and say, look, and we're just here at day 60 or 65 of this lawsuit. The attorney's fees are burning. The claims are going to continue to grow. People are going to understand this case better every week at the law firm that's working on it. You're going to have 47.1. People are going to be scouring it. In fact, Ms. Hudson did a great job. She actually pulled the legislative history of 47.1, which is like 160 pages or something, and you can get it off Pacer. And she attached it to this as an exhibit.
Yeah.
I mean, 47.1 is a game changer.
It's a game changer for this litigation. But, what is Baldoni and the Wayfarer parties to do? And so being in their shoes, especially when they have, who's the billionaire, Sorensen?
Yeah, Steve Sorowitz.
Sorowitz. I always get his name wrong. Sorowitz. They have Sorowitz in their corner. And so it's a little easier to play high stakes poker when you've got a billionaire backing you up. It's a lot harder when you don't have the money in your pocket to play that game. But it is a game of chicken. But what are they to do? I mean, I think that they have to fight against this, oppose it, and maybe even file a second amended complaint and try to clean it up. I don't think that they can just go away on their defamation lawsuit at this point in time. I mean, they can't just, take their ball and go home at this point, because they would still be in the lawsuit with Blake Lively on the SH claims.
Well, let's be clear to our listeners and the jury pool. And again, people obviously are not happy to hear our take on this, I'm sure, but we want to be honest and we want to look at it and call it the way we see it. This is a watershed in this case. This is a watershed now, maybe not in the court of public opinion yet, but this is a watershed from a legal standpoint. This is a seismic shift. There's been an earthquake, an 8.0 earthquake by the name of Esra Hudson. Is that her name? Esra Hudson? Sorry, Esra.
Hudson. Yep.
And she's taken a case where obviously the court of public opinion has already spoken. Everyone's upset at Blake Lively. They're upset at Ryan Reynolds. And here we're just talking about, by the way, Ryan Reynolds doesn't have the same case to apply to himself, right?
No.
And the New York Times can't use this.
Not 47.1.
They can use the reporter's privilege, but they can't use this privilege. So she's a unique defendant in this case where she's going to be able to use this brand new shiny law. There's not a whole lot of cases that have been decided on it, but it looks very broad. And the way that it's been given, I mean, I have to think that Justin Baldoni's team is looking at this. And of course, they're going to come out publicly and say, this is a bunch of nonsense. This is not a big deal. But if I was the lawyer representing Justin Baldoni on this would be a punch to my gut today. I would be going, what are we going to do with this?
It's a legal judo move for sure on the part of Lively and Baldoni and Friedman and their team. They got to take it very seriously. And I'm sure that they're going to have arguments and they're going to mount a good defense, but this is serious.
That's what one of our jury pool members said. Friedman is working on another SH claim right now. I'm 1,000% sure he is not shocked by or unaware of this Me Too law.
Yeah.
And this is a question too. Will Brian Friedman make a statement on this filing? Have people been doing that, or it's just like all paperwork?
I haven't seen any statements on the filings, but I'm sure we'll see an opposition. And the last time we saw an opposition from the Baldoni camp, which was against the New York Times, it was very well done. We are really impressed, I think, with Baldoni's opposition to the New York Times.
How about this one really quick? How would you differentiate between retaliation and self-defense for this case?
Really what the primary thing is, they need to get past the motion to dismiss so they can start developing their facts and getting it in front of the jury. And the way that you prove the difference between that is that you have the facts, you tell the story, you tell the jury what's going on here. And that's going to be the deciding factor. But as of right now, when you're just looking at these privileges and these laws and the motion to dismiss, it's going to be it's a good argument that Lively has presented. It's a really good punch, and I think Baldoni has to find a way to argue back.
Here's another good one that just came in. Friedman stated Baldoni's countersuit was not retaliation. They just replied to Blake Lively's suit with facts. Does this give Friedman to scope to load more facts?
Yes. So that's what the second amended complaint would be for. So even if the court were to grant this motion to dismiss that Lively filed, most likely the court would also give Baldoni a chance to amend, do a second amended complaint, try to fix his complaints and see if he can get the allegations where they need to be to survive a motion to dismiss in the future.
You guys kind of touched on this, but I thought this was interesting too. Melissa says, are you more impressed by Blake's argument for dismissal than Ryan's? I think the answer to that is yes, because everyone roasted that one yesterday.
Emphatically, yes.
And she said, could her case theoretically be dismissed and his case go forward? Referring to Ryan.
Yes. So they're separate parties. I know they're married, but as far legally speaking, they're separate parties to this lawsuit. And so Lively's claims could be dismissed in theory, and Ryan Reynolds' claims could keep going forward. They're not necessarily connected just because they're married. I thought that this, and I think you would agree, right, sir, that this motion was much better done than the one for Ryan Reynolds. The arguments are much stronger. Of course, to some extent, it's easier to be stronger because you have this Civil Code Section 47.1, which is just such a devastating law for Baldoni on this case.
Yeah, I mean, if you had 47.1 on your side, it's easy to draft. Not easy, but it's much easier to draft this. That's 12b6.
Did we want to just mention the Jed Wallace motion since we're talking about motions to dismiss?
Yeah, I think a lot of people were curious about it.
Because Jed Wallace also filed a motion to dismiss. His is very much simpler in its presentation. And really what he's talking about mostly in the Jed Wallace petition is jurisdiction. And so he's saying that New York simply does not have jurisdiction over him. And that's why he sued in Texas federal court when he sued Lively. And it all comes down to what we call personal contacts and cases that were established by International Shoe, which is a case that we all have to read and agonize over in law school. You read International Shoe, didn't you?
I did, yeah. I read International Shoe. It's a good case.
Did you read anything else in law school?
I did. I read a couple other cases while I was in law school, but every law student has to deal with civil procedure right up front. And the seminal case you're going to read is Pennoyer versus Neff. And I haven't looked at Pennoyer versus Neff in probably 23 years, but I was going to be the number one law student in my class. So it's my first year of law school, and I grabbed Pennoyer versus Neff, and that was the first case we had in civil procedure. And I literally spent like 5 hours diagramming it, understanding it. It's not easy to read either. It's, written in the 19th century. It's horrible. And I felt really good about that. So I remember we came to class and we got to present Pennoyer versus Neff, and then we moved on to International Shoe. And I was like, well, wait, what about Pennoyer? But Pennoyer is no longer there.
Because it was overruled by International Shoe.
But it is funny that Jed Wallace, they did point to International Shoe because they're trying to show that there's no minimum contacts with New York. And so, we'll see what the court does with that.
Yeah. And basically they're saying that, look, Wallace nor his company, they don't transact any business in New York. They were not within the state when any of the supposed activities took place there. And so there simply isn't any jurisdictional basis for New York to exercise jurisdiction over Jed Wallace. And even though it's in New York federal court, you still have to have New York jurisdiction for the federal court to hear it in New York. And so his argument is it should either be dismissed or you should just transfer the claims against Jed Wallace to Texas because they already have a pending case in Texas federal court. And so that was really the gist of Jed Wallace's motion. And I think that his jurisdictional arguments are pretty strong. And so it'll be interesting to see what the court does with that. But it seems like there's not a lot of jurisdiction for Jed Wallace in New York.
Got a couple more people to shout out. Jewel says, thanks for your honest opinion.
Well, thank you.
And Anna Fan says, that's why I do tax law. Much easier. Showing my support for you guys.
Yeah. It's pretty bad when tax law is the easier one because tax law is not easy.
Well,
do you have some other questions?
I mean, there's a billion intelligent, comments coming in. I wish we could get to all of them, but
well, maybe I should do to Stuart what he usually the unfair question he asked me, which is, how's the court going to decide?
You know, I haven't called this court. I've called him right 50% of the time. That's not a very good batting average. I think probably he's going to allow a second amended complaint at worst. And he's also going to determine which law applies here. But I'll be in more of a position to make that determination after I see Baldoni's response. And the one thing I am saying here that I like is this is the major leagues of lawyers. This is the top professional lawyers that are on this case. And they're all making each other rise to the highest level. We're seeing some outstanding briefing here. This is like Supreme Court level briefing in a civil case. You just don't see that.
Yeah.
And so the writing, you know, we've attached Esra Hudson's 12B6 motion on behalf of her client, Blake Lively. It's attached in the description under this video. If you want to see good legal writing, if you're somebody thinking about going to law school, or you're in law school, or maybe you're out of law school and you just aren't a good drafter, you know, look at how she weaves the arguments together. It's just a fantastic brief. And whether you agree with it or disagree with it, it's good writing. I remember in law school, I used to read every opinion by Justice Scalia. And I didn't agree with Justice Scalia all that often when I was in law school. But the reason I read every opinion by Justice Scalia was because it was so well written.
Right.
And I learned so much from reading his writing. Are there any writers that you remember reading that had an impact on your style?
Yeah, I think reading Supreme Court opinions was always instructive. There was a couple of appellate attorneys that we worked with where their writing was just phenomenal. And I think that, you know, seeing that level of writing just kind of, not only does it make you a better writer, it makes you better at arguing and thinking and analyzing. And then of course, Brian Garner, who's like, you know, the source of legal writing. Every attorney knows Brian Garner. And the first firm I worked at when I was out of law school, Brian Garner actually came and did a seminar at our office and helped, you know, walk through kind of his writing philosophy. So, but I always say that good writing is good thinking. So you can't write well unless you understand what you're supposed to be talking about. And so the analysis is important. And that's why this brief was, you know, interesting, just because the analysis was weaved together in such a way that it's a strong argument. I didn't feel that way with the Ryan Reynolds motion.
No.
I felt like it was a little bit more bombastic, just for the sake of kind of being a punch to the face. But legally speaking, it didn't make me walk away saying, oh, that's a pretty strong argument. I just kind of felt like, that didn't really impress me.
And of course, that lawyer didn't have 47.1 to work with.
Yeah.
So would it have been a different brief if 47.1 was available?
I'm sure it would have. I mean, you know, anytime you have a statute that's that strong, you're going to exploit it. And that's what they did here. They exploited the heck out of it.
Seems like someone's with you. Jury pool says Scalia is so blunt.
Scalia.
Sorry.
Yeah. He was blunt and he was harsh, but in my opinion, a good writer. Although, you know, John Roberts, the current Chief Justice of the Supreme Court, may be one of the best writers I've ever read as well. I mean, you can't go wrong reading any of the Supreme Court justices. They're all very strong. Of course, they have a team of law clerks that are helping them, but still, they're bright people and they're good, strong writers to become a justice on the Supreme Court.
Yeah, for sure. Yeah, this is really amazing just to see this level of lawyering.
I don't want to put this person on blast or anything, but they say you two act like New York Times is the Bible. I think I speak for all of us. We do not think that. Yeah.
No.
Just want to set that straight.
I'm not even sure where that came from, but okay.
No.
Mark Spence says, the jury pool says, what the heck is international shoe? I'm wondering. It sounds kind of funny.
I know. I want to know that too. So it's a case that was decided. Hold on. Let me pull it up here because I have it in front of me. I don't even remember. It's decided so long ago.
54, I believe.
45. So International Shoe Company versus Washington. And so it was a United States Supreme Court case from 1945. And it set really the standard and the elements that you need to meet for a state to have jurisdiction over an individual. So if you live in California, you can't be sued in New York unless you meet the elements of International Shoe versus Washington. Now, I don't know what International Shoe Company was back in 1945. Maybe somebody can look it up for us and tell us what that was. But reminded me of, I think, David Letterman's production company is called Worldwide Pants. So I thought, well, maybe. But I think it was a real business, and it was being sued, and it took its case all the way up to the U.S. Supreme Court, and the U.S. Supreme Court set the standard for what elements you must meet for a court to have jurisdiction over you in a particular state. I'm glad somebody asked that question because we were kind of talking about it as if it was a known thing.
So according to ChatGPT, which is not always right, International Shoe as a company isn't around anymore, but they shut down in 1996
Oh, they made it a long time.
after being around for almost 90 years, but their legacy definitely lives on.
With every law student.
Yes. But I want to know what happened to Penoyer versus Neff.
Yeah,
that was
I
out
don't
of
know.
Oregon, I believe. Wasn't it Oregon, Washington State, somewhere up in
Was
the
it? I
Pacific
don't even
Northwest?
remember.
Yeah. I used to know it all, but
I didn't pay attention to it because it was overruled.
Yes. Right. Yes. Somebody should have told me about that. Yes.
Right.
We're closing in on an hour, so maybe we'll wrap up with this. T says bombastic. Love hearing Keith say bombastic.
There you go.
Thanks, T. Appreciate
I
that.
have a few words.
Yeah.
So we'll end today saying, hey, thanks for everybody. We have 4,300 people watching us. We want to say thank you. It wasn't the news that probably a lot of people wanted to hear today. Hopefully it's been taken. Hopefully you're not upset at us for the news. We just wanted to report it the way we saw it. Thank you for being here. We're interested always in hearing your comments, and we'll respond to those when we get around to doing it. So thank you for taking your time to join us today.
Yeah, that's fantastic. And we're looking forward to seeing the opposition.
And when we do the opposition, we'll be fair to that as well.
Yeah, absolutely. Well, have a good afternoon.
See you guys.